Your house is paid off. Your will is in a drawer. You think everything is taken care of. It is not. 5 mistakes are quietly sitting inside American estate files right now, and most families will not discover them until it is too late to fix them. By then, the IRS has taken a piece, the state has taken a piece, the bank has taken a piece, and the children are in court trying to undo damage that a single conversation with an attorney could have prevented entirely. A $400,000 home in the wrong setup can cost a family $75,000 in capital gains tax that nobody had to pay, another $20,000 in probate fees, another $60,000 in lost equity from a forced sale. 3 mistakes, and the children inherit roughly half of what the parent thought they were leaving behind. The 5th mistake on this list will cost more than the other 4 combined, and almost no family has ever heard of the federal law that protects them from it. Mistake 1. Adding your children to the deed. The instinct makes complete sense. The parent wants to make sure the children get the house, figures probate is expensive, and adds the children's names to the deed. Done. That single decision can cost the family $75,000 or more in capital gains tax that nobody had to pay. Here is why. Section 1014 of the Internal Revenue Code, the stepped-up basis rule, says that when children inherit a house through an estate, the cost basis resets to the fair market value on the date of death. House bought for $60,000, worth $400,000 at death. The children's basis becomes $400,000. They sell it the next day. 0 capital gain, 0 tax. But adding children to the deed during the parent's lifetime is a gift. A gift transfers the parent's original low basis. When the children eventually sell, the taxable gain is calculated against that original $60,000, not the $400,000 value at death. The tax bill runs between $50,000 and $75,000. There is also a second problem. Once the children's names are on the deed, the parent has given them a legal ownership interest. If one child is sued, divorces, or files for bankruptcy, the parent's house is now exposed. The fix is simple. A transfer on death deed, available in roughly 30 states, achieves the same probate avoidance without triggering the tax problem or the creditor exposure. The parent stays the sole owner during their lifetime. At death, the house transfers automatically with the full stepped-up basis intact. Recording one costs between $100 and $500. Getting it wrong costs up to $75,000. The math is not close. Mistake 2. Naming one child as a joint tenant. The parent picks the most responsible child and adds them as a joint owner with rights of survivorship, expecting that child to inherit the house and share the proceeds with the siblings fairly. That expectation has no legal weight whatsoever. Joint tenancy with rights of survivorship means the surviving joint tenant automatically takes the entire property by operation of law. Whatever the will says about splitting the house equally is completely overridden the moment one child's name appears on that deed as joint tenant. That child is now the legal owner of the entire house. Sharing with siblings is a personal choice, not a legal obligation. The catastrophic outcome is that the named child gets sued, divorces, or files for bankruptcy before the parent dies. The court can attach the house, an ex-spouse can claim half, a bankruptcy trustee can force a sale. The parent loses their home through nothing more than their child's personal legal trouble. The solution is the same as mistake 1, a transfer. On death deed or a properly structured revocable living trust keeps the parent in full control and protects the home from the child's creditors entirely. Mistake 3, the quitclaim. A quitclaim deed transfers whatever interest the parent has in the property to a named recipient. It costs as little as $50 at the county recorder's office, and it is one of the most damaging documents a senior can sign without an attorney. The most dangerous version involves Medicaid planning. A parent hears that Medicaid will not pay for nursing home care if they own a home above a certain value. So they quit-claim the house to the children, believing this qualifies them for Medicaid coverage later. Medicaid has a 5-year look-back period. Any uncompensated transfer, including a quitclaim of the family home, triggers a penalty period of ineligibility. Medicaid calculates the value of the transferred asset, divides it by the average monthly nursing home cost in that state, and that number becomes the months the family pays out of pocket before Medicaid covers anything. A father who quitclaims a $300,000 home in 2023 and needs nursing home care 2 years later can face a 40-month penalty period at $7,500 per month, meaning the family owes $300,000 in out-of-pocket costs before Medicaid pays a single dollar. The transfer meant to protect the house ends up costing the family the equivalent of its entire value. Mistake 4. Doing nothing. First 3 mistakes are mistakes of action. This one is the opposite and just as costly. The parent does nothing. The will sits in a drawer. At death, the house drops into probate. Most parents assume the will handles the house automatically. It does not. The will sends the house through probate court first, a court-supervised process that verifies the will, pays outstanding debts, and confirms rightful heirs. It takes between 6 and 18 months. The cost runs between 3 and 7% of the estate's gross value. On a $400,000 home, that is between $12,000 and $28,000 before attorney fees. But the worst part of probate is not the cost. It is the freeze. While the house is in probate, the family cannot sell it, cannot refinance it, and in some states cannot authorize even routine maintenance without court approval. Mistake 5. Leaving the mortgage. In the deceased's name. This is the mistake most families never see coming, and it is the most expensive one on this list. Most residential mortgages contain a due-on-sale clause, a provision that gives the lender the right to demand full repayment when the property changes hands. The death of the borrower can technically trigger this clause. When it does, the lender sends the surviving family a demand letter. The full mortgage balance comes due, often within 30 days. If the family cannot refinance, the bank forces a sale. Lost equity from a forced sale routinely runs between $40,000 and $100,000. But there is a federal law that protects most American families from exactly this, and almost no family has heard of it. The Garn Saint-Germain Depository Institutions Act of 1982 prohibits a lender from invoking the due-on-sale clause when residential property transfers from a deceased borrower to a relative who occupies the property. 5 steps to take this week: pull a copy of the deed from the county recorder's office. Confirm whose name is on it. If anyone other than the homeowner or their spouse appears, that is the starting point of an urgent conversation with an elder law attorney. Find out whether your state allows a transfer on death deed beneficiary. Deed or ladybird deed. Recording one is among the highest leverage steps any homeowner over 60 can take. Locate the most recent mortgage statement. Write down the servicer's name, the loan number, and the current balance. Place it with the will and deed copies. This is the document the family will need within 30 days of the parent's death to assert the Garn Saint-Germain protection. Write down which children should inherit the house and how. Do not rely on a verbal understanding. Bring that list to an attorney consultation. Schedule 1 hour with an elder law attorney. Bring the deed copy, the mortgage statement, and the inheritance list. Ask specifically about transfer on death deeds, Medicaid look-back windows, and the Garn Saint-Germain's notice procedure. The families who lose the most are not the ones who lacked the money to protect themselves. They are the ones who simply did not know these mistakes existed until it was already too late. Now you know. Talk to a licensed elder law attorney in your state before any of these 5 mistakes quietly become yours. If this video opened your eyes to something you did not know before, hit that like button. It helps more families find this information before it is too late. Subscribe to the channel and turn on notifications so you